Part 2 Evidence. Some distinctions between evidence in civil cases and evidence in criminal cases. Sec. 2 of Rule 128 declares that the rules on evidence shall be the same in all trials and hearings, except as otherwise provided by law or these rules. To declare such is not to say, however, that there are absolutely no distinctions between a civil and a criminal proceeding. Indeed, there are certain evidentiary differences between these proceedings. A. In civil cases, the party having the burden of proof must prove his claim by a preponderance of evidence. Sec. 1 Rule 133, Rules of Court. In criminal cases, the guilt of the accused has to be proven beyond reasonable doubt. Sec. 2 Rule 133, Rules of Court. B. In civil cases, an offer of compromise is not an admission of any liability, and is not admissible in evidence against the offerer. In criminal cases, except those involving quasi-offenses, criminal negligence, or those allowed by law to be compromised, an offer of compromise by the accused may be received in evidence as an implied admission of guilt. Sec. 27 Rule 130, Rules of Court. C. In civil cases, the concept of presumption of innocence does not apply and, generally, there is no presumption for or against a party except in certain cases provided for by law. Example, a common carrier is presumed to have been at fault or negligent in case a passenger is injured in the course of his transportation by the carrier. Art. 1756, Civil Code of the Philippines. In criminal cases, the accused enjoys the constitutional presumption of innocence. Sec. 14, Art. 3, Constitution of the Philippines. D. The concept of confession does not apply to civil, which use the more appropriate term, admission. A confession is a declaration of an accused acknowledging his guilt of the offense charged. See Sec. 33 Rule 130, Rules of Court. E. In civil cases, evidence of the moral character, good or bad, of a party is admissible as long as it is pertinent to the issue of character involved in the case. Sec. 51b, Rule 130, Rules of Court. In criminal cases, the prosecution is not allowed to prove the bad moral character of the accused even if it is pertinent to the moral trait involved. It can only do so in rebuttal. Sec. 51(2), Rule 130, Rules of Court. F. The rule on disqualification by reason of death or insanity under Sec. 23 of Rule 130, applies only to civil cases or special proceedings, not to criminal cases. This is because the rule involves a claim or demand against the estate of the deceased or the person of unsound mind. Sec. 23 Rule 130, Rules of Court. G. The privileged communication rule on patient-physician relationship has reference only to a civil case, not to a criminal case. Sec. 24 C. Rule 130, Rules of Court. H. The rule on admission by a conspirator applies only to a criminal case, not to a civil case. Sec. 30 Rule 130, Rules of Court. I. The rule on extrajudicial confession applies to the accused in a criminal case, not to the defendant in a civil case. Sec. 3 Rule 133, Rules of Court. Distinction between proof and evidence. 1. Proof is not the evidence itself. There is proof only because of evidence. It is merely the probative effect of evidence and is the conviction or persuasion of the mind resulting from a consideration of the evidence. 29 M. Ur. 2d. Evidence, Section 2. 2. Proof is the effect or result of evidence, while evidence is the medium of proof. Jones on Evidence, Volume 1, 4th edition, Section 4, p. 5. Factum Probandum and Factum Probans. 1. Evidence signifies a relationship between two facts, namely, a, the fact or proposition to be established, factum probandum, and b, the facts or material evidencing the fact or proposition to be established, factum probans. Wigmore, Principles of Judicial Proof. 5. 2. Stated in another way, the factum probandum is the fact to be proved, it is the fact which is in issue in a case and to which the evidence is directed. On the other hand, factum probans is the probative or evidentiary fact tending to prove the fact in issue. Black's Law Dictionary, 5th ed., p. 533. Thus, if P claims to have been injured by the negligence of D, who specifically denies having been negligent, the negligence of D that caused the injuries of P constitutes the factum probandum of the suit. The evidence offered by P, whether it be object, documentary or testimonial, constitutes the materials to prove the liability of D. The totality of the evidence to prove the liability refers to the factum probans. 3. The factum probandum in a certain case may be affected by the judicial admissions of a party. For instance, if the defendant in a suit based on a culpa aquiliana theory admits his negligence in his answer to the complaint, there is 10 more need to prove negligence. Hence, negligence ceases to be a factum probandum in the case. If the factum probandum signifies the fact or proposito be established, then matters of judicial notice, conclusive presumptions and judicial admissions cannot qualify as parts of the factum probandum of a particular case because such matters need not be established or proven. 4. In practical terms, the factum probandum in a civil case refers to the elements of a cause of action alleged in the complaint as denied specifically by the defendant. For instance, in a suit for collection of a sum of money, in the absence of any admission by the defendant, the factum probandum of the plaintiff would be I. The existence of the debt of the defendant, e. The maturity of the debt, e. The demand made by the plaintiff upon the defendant to pay, and iv. The failure to pay despite the demand. If the fact of non-payment is the only matter disputed in the answer, then it is only the issue of payment or non-payment which constitutes the factum probandum in the case, other allegations having been admitted. It must be clarified, at this juncture, that the mere filing of the complaint does not ipso facto give rise to a factum probandum. When the defendant files his answer and makes no specific denial of the averments of the complaint, no factum probandum arises because of the admissions. Where, let us say, the defendant specifically denies a material allegation in the complaint, the matter denied becomes the factum probandum, the fact to be established. The same rule applies to a criminal case. The mere filing of an information does not automatically give rise to a factum probandum. It only arises when the accused enters a plea of not guilty. 5. In a criminal case, when the accused pleads not guilty, the factum probandum refers to a matter that the prosecution must prove beyond reasonable doubt in order to justify a conviction. Thus, in a prosecution for robbery, the prosecution has the burden to prove the following matters beyond reasonable doubt: I. That there be personal property belonging to another, e. That there is unlawful taking of that property, e. That the taking is with intent to gain, and iv. That there is violence against or intimidation of persons or force upon things, art. 293, Revised Penal Code, People v. Sandoval, 254 SCRA 436. b. To convict an accused for illegal possession of firearms and explosives, the following two essential elements must be indubitably established, each of which is a factum probandum: I. The existence of the subject firearm or explosive which may be proved by the presentation of the subject firearm or explosive or by the testimony of witnesses who saw the accused in possession of the same, and e. The negative fact that the accused had no license or permit to own or possess the firearm or explosive which may be established by the testimony or certification of a representative of the PNP Firearms and Explosives Unit that the accused has no license or permit to possess such firearm or explosive.